Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. This case is short, but the legal principle it established is enormous. Have you ever bought something thinking it was one thing, only to find out the seller knew you were wrong but didn't say a word? In 1871, a horse trainer named Hughes learned a very expensive lesson about oats. Today, we're breaking down this landmark case so you don't make the same mistake in your own business deals. Alright, let's start with the real-world problem. This is the part that helps you understand what is actually going on before you spend money on a legal dispute. In this case, a farmer sold oats to a horse trainer. The trainer thought he was buying old oats, which are better for horses, but the farmer was actually selling new oats. The problem was that the trainer never explicitly asked for old oats out loud, even though that's what he wanted. This is a classic example of a mistake in quality that can lead to a massive bill if you aren't careful. The farmer knew the oats were new, and he likely knew the trainer wanted old ones, but he stayed quiet. In many business deals, people think silence is the same as fraud, but the law often says otherwise. Unless the seller actively lies, they generally aren't required to correct your own internal mistakes. This means you need to ask the right questions rather than assuming the seller has your back. Before the deal was struck, the trainer was actually shown a sample of the oats. He had the chance to inspect them but didn't realize they were new. This is a critical point. If you're given the opportunity to check the goods and you miss a detail, the law is much less likely to help you out later. Always take the time to verify the sample matches your specific needs. Now let's look at how a court actually decides if a contract exists when two people walk away with different ideas. Courts don't have a window into your brain, they look at your outward actions. If a reasonable person watching the deal would think you agreed to the terms, then you probably did. This is called the objective theory of contract. It means that what you meant to say matters far less than what you actually did or signed. This Latin phrase means a meeting of the minds. For a contract to be valid, both parties need to agree to the same thing. However, Smith v. Hughes clarified that if one party acts in a way that leads the other to believe they're agreeing, the contract stands. You can't just back out later by saying, "That's not what I was thinking." This is the most important distinction in the case. If the trainer thought the contract said old oats, he might have won. But because he only thought the oats themselves were old, he lost. You have to distinguish between what the contract promises and what you personally believe about the item's characteristics. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. This chapter deals with the risks you take every time you buy something without a written warranty. Smith v. Hughes is a foundation for the buyer beware rule. In a commercial setting, the buyer is expected to look after their own interests. If you don't ask for a warranty or a specific guarantee, you're essentially accepting the risk that the product might not be exactly what you hoped for. It's a harsh but necessary rule for market stability. While silence is usually okay, there are red flags to watch for. If a seller actively hides a defect or lies when asked a direct question, that's fraud. The takeaway here is to always ask direct, specific questions. Are these oats old? Is a much better question than, are these good oats? Because it forces a factual answer. Often, people skip thorough inspections because they want to save time or money. In the Smith case, the cost of a closer look at the sample would have been pennies compared to the cost of the useless oats and the subsequent lawsuit. Always factor in the cost of verification before finalizing a deal. It's almost always cheaper than a lawyer. Let's talk about how to apply these 150-year-old lessons to your modern business or personal life. The easiest way to avoid a Smith v. Hughes situation is to include the specific quality you need in the written contract. If the trainer had simply written old oats on the receipt, the farmer would have been in breach of contract for delivering new ones. Never leave your may want to have features to a verbal understanding or an unspoken assumption. When buying goods, especially in bulk, use a subject to inspection clause. This gives you a legal window to reject the delivery if it doesn't meet your expectations. This shifts the risk back toward the seller and ensures you aren't stuck with a product that doesn't fit your specific use case, like new oats for an old horse. A warranty is a promise that the goods will meet a certain standard. If a seller is unwilling to provide even a basic warranty for quality, that's a massive red flag. In the Smith case, the lack of a warranty meant the buyer was flying solo. Always ask for a written guarantee of quality if that quality is essential to the deal. Finally, let's look at the costs of fighting these battles and how to decide if you should go to court. Lawsuits over contract misunderstandings are notoriously expensive because they often require expert testimony to explain industry standards. Before you sue, calculate the difference between the value of what you got and what you wanted. If the legal fees exceed that gap, it's usually better to settle or walk away. When you see the phrase "as is" in a contract, the ghost of Smith v. Hughes is present. This is a legal signal that the seller is disclaiming all responsibility for the quality of the item. Unless you're an expert in what you're buying, "as is" should always trigger a professional third-party inspection before you pay a single dollar. If a contract involves a significant amount of money or a specialized product, have a professional review the terms. A few $100s for a contract review can save you thousands in a mistake of qualities dispute. If the other party is using complex language or seems to be dodging specific questions, that's your cue to seek expert advice. That's the practical version of what matters most from Smith v. Hughes. The big idea is that your internal thoughts don't create a contract, your outward actions and specific words do. By being precise, asking direct questions, and never assuming the seller is correcting your mistakes, you can stay out of the courtroom and keep your business running smoothly. If this helped you understand how to protect your interests in a deal, like and subscribe for more practical guides. We're here to help you navigate complex rules so you can make smarter decisions with confidence. Subscribe for more case summaries that make bar exam prep easier. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.